Now on to today's case of R v Moloney, 1985, with the Part B recording. The House of Lords provided a ratio decidendi, which means reasons for the decision, which forms a binding precedent or legal decision or legal principle in the case of R v Moloney, 1985, which is still law today, which was to state that the legal test of foresight of consequences is only evidence of intention, not intention itself. This is because it is usually for the jury, who are the deciders of fact, at trial in the Crown Court, seeing as most of these case developments regarding the tests used for indirect intent at one point in time revolve around the law of murder. Hence why it is for the jury to decide at trial whether the defendant is guilty of murder via a possible indirect intent, where there is no direct intent. Therefore, a jury would have to be convinced by the legal test put forward by prosecution lawyers at, say, a murder trial in the Crown Court about whether the defendant had a foresight of consequences of death or serious injury. If convinced, the jury would then go on to give their verdict, finding the defendant guilty of murder. In doing so, the jury would pretty much have decided that due to being convinced by the legal test of foresight of consequences, this amounted to the defendant having an indirect intent for the crime of murder. However, just to stress, foresight of consequences is evidence of indirect intent, not actually indirect intent, as this is usually for the jury to decide. In R v Moloney, the case involved the defendant and his stepfather, who had a good relationship, engaging in a contest to see who was the fastest at loading and firing a shotgun. This was done after a family party where both the defendant and the stepfather had drank a lot of alcohol. They were even heard talking and laughing after the party before the gun contest. The defendant managed to beat his stepfather at loading his gun faster, and the stepfather then said to his son that he didn't have the guts to pull the trigger. The defendant claimed after shooting his stepfather that he didn't aim the gun at all, but just pulled the trigger, and his stepfather was dead. At trial, the defendant was found guilty of murder, but on appeal his conviction was quashed. The House of Lords then took the opportunity to stress that foresight of consequences is simply evidence of intention, not intention itself. Other parts of this judgment have been overruled by later cases though, such as Lord Bridges' part of the judgment when creating a now old test for foresight of consequences, which was for the jurors to be asked two questions. Question 1, was death or serious injury a natural consequence of the defendant's act? And question 2, and secondly, did the defendant foresee that consequence as being a natural result of his act? The problem with Lord Bridges' questions here is that they miss out the word probable, which had been used within Section 8 of the Criminal Justice Act 1967, where the earlier phrase of natural and probable consequence had been used for an earlier form of the foresight of consequences test. This two-part test in Moloney clearly confused the law slightly. And that's it for today. In the next recording, I'll take a look at R v Hancock and Shankland, 1986. Thank you from Law with Dunk the Law Guy, and I'll see you tomorrow.